Okay, let's unpack this. Imagine this. You're driving home late at night, maybe with your family. Another car is right on your tail, flashing brights, driving erratically, dangerously even. Your anger flares up, frustration's building. What happens next? How much control do you actually have? And what does the law say about that moment? Today, on the deep dive, we're taking a shortcut, really getting into a pivotal South African legal case, SVED. It explores exactly these kinds of questions. So, this deep dive is definitely for you if you're prepping for a law class, or maybe you're just really curious about where human emotion, meets legal accountability. What does it truly mean to lose control? Is it like flipping a switch, or more of a slippery slope? This case, well, it draws a very sharp line.
Yeah, and what's so fascinating here, I think, is how this one single, really tragic road rage incident became such a defining moment, especially for this defense of non-pathological criminal incapacity in South African law. Basically, this defense tries to argue that someone wasn't criminally responsible because, due to extreme stress or emotion, they temporarily lost the ability to control their actions, even if they sort of knew what they were doing was wrong. So our mission today is to explore the gritty details of this case, the complex legal arguments that came up, the court's really powerful reasoning, and ultimately its lasting impact on how the law sees those moments where people claim they just.
Right. By dissecting this case, we're not just looking at like dry legal precedent. We're digging into the very limits of human control and legal responsibility. And that might offer some, well, unexpected perspectives, I think. Okay, so our story starts really early in the morning, Saturday, June 12th, 1999, on a road called Ukapsaweg. It's near Fishhook in South Africa. And this is where Graeme Michael Eadie, the man at the center of this case, found himself in this absolutely terrifying road rage incident. An incident that ended tragically with the death of Kevin Andrew
And
Duncan.
if you think about the bigger picture, road rage is unfortunately something a lot of people can relate to, at least the feeling of it. The High Court even mentioned it when sentencing Edie. They said, the average driver is often dealing with anxiety, stress, antagonism, frustration, which can kind of feed into these incidents. This case really put that whole phenomenon under the legal microscope.
So, what exactly happened? What set the scene? Eadie, he was 37, described as a keen sportsman. He was driving his wife and two young kids home from a hockey club function. Now, he'd had at least 7 beers there. And then afterwards, at a restaurant, another 2 beers and 2 Irish coffees, his blood alcohol level. Around 0.15 grams per 100 milliliters, way over the legal limit.
Yeah, and crucially, the deceased, Mr. Duncan, he was also significantly intoxicated. His
Yeah.
level was 0.17 grams per 100 milliliters. So this context, this kind of shared inebriation, is really important for understand how things escalated so quickly.
Right. So Edie's driving along, and Duncan's car, a Toyota Corolla, comes up fast behind them, headlights on bright, overtakes them, then slows right down to maybe 40 kilometers per hour. So Edie overtakes him. But then Duncan does the same thing again, speeds up, gets right on Edie's bumper, bright
Right.
blazing. Edie tries to speed up, get away, but he can't shake him. He starts getting really enraged, but also, genuinely scared for his family. He pulls over, stops at a traffic light, and Duncan stops right behind him.
And this is such a critical moment, isn't it? What happens when that fear, that protective instinct for your family, crashes into intense anger? Edie gets out of his car, he reaches behind his seat and grabs a hockey stick. His wife sees what's happening, sees his intent, and very wisely, she just drives off with the children.
Yeah, good call. Edie apparently first intended to just smash the Toyota's headlights. Then he thought, no, the windscreen. But just then, Duncan opens his car door. Edie lunges at him with the hockey stick, but it breaks on impact. And that's when, in Edie's own words, things got extremely angry.
Yeah.
He forces Duncan's door open again, starts punching him repeatedly while Duncan is still inside the car. Then he pulls him out of the car and then savagely stamps on his head with his heel. Broke Duncan's nose in the process. Just brutal.
So Edie's defense, it was this specific defense, temporary non-pathological criminal incapacity. Now, it's important to understand, this is different from pleading insanity or having a diagnosed mental illness. At its core, this defense is about whether someone was genuinely, truly incapable of controlling their actions in that moment. Not just, whether they lost their temper badly. Think of it like almost like someone physically forcing your hand to do something, but the force is internal, driven by extreme factors. Things like emotional stress, provocation, maybe intoxication playing a part. Edie actually conceded. He admitted he knew the difference between right and wrong at the time. But he claimed he simply could not control his actions when it mattered.
That's a fascinating claim. He described his state during the assault like being in a fishbowl, shouting but hearing no sound, seeing some things clearly, others blurred. He said he felt no weight when he pulled Duncan out of the car. And he described this feeling of just going, going, going from the moment the hockey stick broke. But, and this seems really important, he could still remember and describe the whole assault in quite a lot of detail later on. Is that something common in these kinds of cases, where someone claims they were sort of out of it, but they remember everything?
Absolutely. That's often a major challenge for this type of defense, that detailed recall. The defense tried to explain Eadie's state by pointing to other stressors in his life at the time. Things like financial problems, issues at work, maybe some marital tension, a generally depressed mood. His lawyers also brought up two past incidents they thought were relevant. One was way back in 1990, another road rage incident in Johannesburg where he was actually assaulted by people claiming to be police and he got knocked unconscious. And another, even earlier, in 1986, apparently a mental breakdown after military service where he was assessed as having poor impulse control.
Okay, so it definitely wasn't a simple case. And the next stage, the trial, it really became this battle of the experts, didn't it? You had psychologists, psychiatrists, all weighing in with pretty different opinions on Eadie's state of mind.
Exactly. You had Mr. Stephen Lay, a psychologist testifying for the state. He saw Eadie as someone who tended to bottle up his emotions. And Lay viewed Eadie's actions during the assault as rational, purposeful, goal-directed. Basically, he thought Eadie intended to commit a violent act and, crucially, had the cognitive wherewithal, as he put it, to realize Duncan had fallen down. Lay was pretty skeptical about the whole disorientation claim, especially, like you said, because Eadie could remember it all so clearly. He really wasn't willing to concede that Eadie had lost control. He called that expression too vague, too general.
Okay, so that's one view. Then there's Dr. Sean Kaliski, a prominent psychiatrist, also for the state, and he was, let's say, openly skeptical of this whole defense from the start. He even mentioned that in something like 90% of his cases where this defense was raised, in his experience, it had never actually been successfully proven.
Yeah, Kaliski drew this really strong comparison between this non-pathological incapacity defense and something called sane automatism. Now, sane automatism. Think of it like sleepwalking, maybe, or like a complete blackout state brought on by extreme shock. Your body's moving, but your conscious mind isn't really driving. The actions are unplanned. You don't really appreciate what's going on around you. And afterwards, usually there's this sense of bewilderment, horror maybe, and typically no effort to try and cover things up or deceive anyone. Kalisk argued Eadie's actions were just too goal-directed, too consistent with someone who was conscious in making decisions. And the fact that Eadie seemed to have the presence of mind later to take his kids home and then try to mislead the police, well, that seriously undermined the claim of genuine disorientation in Kaliski's view. His conclusion was basically, temper and rage, sure, they might lower your inhibitions, but they don't actually rob you of control in the legal sense.
Wow, okay. But the defense had their own expert too, right? Another psychiatrist, Dr. Ashraf Jadar.
Yes, they did. And Dr. Jadar had a different take. He argued that the sensations Eadie described the fishbowl, the blurred vision, were actually indicative of a dissociative state, sort of an altered state of consciousness where his thinking, his cognition was disturbed. And this disturbance, Jadar argued, led to an inability to control his behavior.
So Jadar thought there was a genuine lack of control.
He did. Jadar also suggested that Eadie might have been, in a way, re-experiencing that traumatic 1990 Johannesburg incident during this road rage event. Now, interestingly, Jadar did concede that Eadie's detailed memory of the assault itself negated any suggestion of true automatism, like the sleepwalking example. But he still insisted that Eadie lost his power to make decisions from the moment the hockey stick broke. Because of the perceived threat, his actions became, in Jadar's view, involuntary, even if they looked goal-directed. And this raises that really tricky question. Can actions be goal-directed but still involuntary? That was a central tension the court had to grapple with.
So you have these conflicting expert views. How did the trial judge, Greasel J., handle it?
Well, Justice Greasel ultimately rejected Eadie's defense. He pointed out the, quote, confusion that seemed to exist between non-pathological incapacity and sane automatism. And he concluded that maybe the distinction might be one without a difference. A subtle but important point. He looked at Eadie's behavior, how focused it seemed, how goal-directed, and importantly, how he tried to deceive people afterwards, and saw that as indicating presence of mind. He also dismissed the idea that Eadie's life stressors caused the incapacity. He made a pretty stark comment, something like, hundreds of thousands of people daily find themselves in similar or worse situations, yet they do not go out clubbing fellow motorists to death. His conclusion was very clear. Eadie didn't lose control in the way the law understands it. He simply lost his temper.
And so Eadie was convicted of murder.
That's right. But it didn't end there. Eadie appealed. On appeal, his lawyers argued that the trial court fundamentally misunderstood the defense. They said the judge confused automatism with non-pathological criminal incapacity. Their point was, look, if Eadie could still distinguish right from wrong, which he admitted, then you'd expect his behavior to be somewhat goal-directed. So holding that goal-directed behavior against him was, in their view, a misdirection by the judge. And they pointed to several older high court cases, names like S.V. Arnold, S.V. Nursing, S.V. Moses, S.V. Gesualdo, where this kind of defense had actually been upheld even when there was goal-directed conduct involved.
Okay, so the plot thickens. Conflicting experts, conflicting past court decisions. Where did the Supreme Court of Appeal go from there? It sounds like they really needed to clear things up.
They absolutely did, and that's exactly what they set out to do. The judgment, delivered by Justice Nasa, really reads like a deep dive in itself. They meticulously went back through the legal history, like legal archaeologists, as you said, trying to bring some definitive clarity to this very murky area of law.
So what was their starting point?
They started by reaffirming the basic test for criminal capacity, which comes from an earlier key case, S.V. Lopsher. It's a two-part test. First, could the person distinguish between right and wrong? And second, could the person act in accordance with that understanding? Could they control themselves? Now, this defense, non-pathological criminal incapacity, it often gets talked about using terms like Weerstandskrag, which means power of resistance, or drang and urge. It kind of suggests an inability to resist temptation or an urge. But as the appeal court made very clear, no self-respecting legal system can just excuse someone because they simply gave in to temptation or anger. The law assumes we have free choice, and with that choice comes responsibility.
Okay, that makes sense. So did they look at how this defense had been treated by the Supreme Court of Appeal before?
Yes, very carefully. They reviewed all the previous SCA cases that dealt with this specific defense, and they emphasized again and again that courts approach these defenses with extreme caution. They're considered most uncommon, really reserved for truly exceptional cases.
It sounds like a very, very high bar to meet then. Is it almost impossible to prove, or are there specific situations where it might genuinely apply?
It is an extremely high bar, and this is where another case they discussed, S.V. Wyde, becomes so critical. S.V. Wyde is actually the only case where the Supreme Court of Appeal had ever upheld this specific defense. And the circumstances there were truly extraordinary. The woman involved had suffered severe, prolonged physical and emotional abuse. She was on sedatives, she'd been drinking, and she suffered a concussion right before the shooting incident. Her memory of the event was vague, she seemed completely bewildered afterwards, and her actions were totally out of character for her. In that specific, extreme context, the court found there was reasonable doubt about her criminal capacity. So Wyde really illustrates the kind of extreme, almost overwhelming circumstances needed for this defense to even have a chance of succeeding.
Wow, okay, so Wyde is the one exception that proves the rule, almost. And I assume they contrasted that with all the times the defense didn't succeed.
Exactly. They drew a very sharp contrast by looking at a whole string of other cases. Kalogeropoulos, Potgieter, Kansley, Henry, Cunningham, Francis, Koch, where the defense was firmly rejected. In all those cases, even when there was evidence of stress or provocation or intoxication, the accused actions were ultimately seen as too planned, too goal-directed, or just too indicative of someone being conscious and aware to justify saying they lacked capacity. The court kept warning against this confusion. Don't mix up simply losing your temper, even really badly, with a genuine loss of cognitive control over your actions.
So what about those high court cases Eadie's lawyers mentioned, like Moses and Gesualdo, where the defense was accepted despite goal-directed actions? How did the SCA deal with those?
Yeah, that was a crucial point. Justice Navsa addressed those directly. He basically stated that some high courts, maybe sometimes out of sympathy for the accused or the specific sad circumstances of a case, had, quote, resorted to reasoning that is not consistent with the approach the Supreme Court of Appeal had already established. He argued that these problematic high court judgments, like Moses and Gesualdo, had effectively blurred a really important line. They had turned provocation, which should normally just be a factor considered in sentencing, maybe making the punishment less severe, into something that could completely excuse the crime, leading to an acquittal. And allowing provocation to completely excuse the crime like that, he said, flies in the face of the fundamentals of any self-respecting system of law.
Ah, okay, so the difference between something mitigating the sentence versus completely exculpating the person, making them not guilty at all. The SCA was saying provocation doesn't get you off the hook entirely.
Precisely. Mitigating means it might make your sentence lighter. Because, yes, you were provoked. Exculpatory means it excuses you altogether. The court was firm. Being provoked doesn't absolve you of criminal responsibility.
Okay, let's try and pull all these threads together then. After looking at all this history, all these cases,
Yeah.
what was the ultimate definitive conclusion from the Supreme Court of Appeal in Eadie? What's the big takeaway about rage and responsibility?
The core clarity, the absolute bottom line from SV Eadie is this. There is no meaningful legal distinction between sane automatism, that sleepwalking state, and non-pathological criminal incapacity that's claimed to arise from emotional stress and provocation. They are, in the court's own powerful words, flip sides of the same coin. What really becomes clear when you look at the expert debates and the court's final ruling is that the law isn't primarily interested in how you felt inside that internal fishbowl feeling Eadie described. That feeling doesn't automatically equal legal incapacity. The law looks at what you did and whether you retain control. So if an accused person truly lacks self-control to the point of incapacity, they're essentially acting like an automaton. Their actions are unconscious, involuntary. If you can still tell right from wrong, then to escape liability by claiming incapacity, you basically have to prove your actions were involuntary in that automaton sense. Your conscious mind wasn't directing the show at all.
So the court is essentially setting a standard based on observable actions and common human experience. Like, we've seen how people behave under stress, and unless your situation is truly extraordinary, like the Wyatt case, we expect you to maintain control.
That's a very good way to put it, precisely. The court confirmed that judges have to test an accused person's claims about their mental state, not just against what the accused says, but critically against their actions before, during, and after the event. And judges must weigh all that against the court's own experience of human behavior and general societal norms. The court called this a necessary break, a way to prevent the defense from being stretched too far, potentially excusing behavior that society rightly expects people to control. You can just imagine the tension in that courtroom, can't you? Top legal minds debating the very nature of consciousness under extreme pressure.
Absolutely. So applying this clarified standard back to Eadie himself, what was the final outcome of his appeal?
The appeal court found that Eadie's actions were clearly not automatic. His behavior fueled by anger, yes, but also goal-directed and violent, combined with his detailed memory afterwards and his attempts to deceive the police. All of that pointed towards presence of mind. He lost his temper, spectacularly and tragically, but he did not lose control of his actions in the sense required by law to escape criminal responsibility. So the trial court's original conclusion of guilt for murder and the finding that Eadie had the necessary legal intention to kill were both upheld. And this ruling wasn't just about Eadie. It fundamentally reshaped how all South African courts would have to approach these loss of control claims going forward. It drew a much tighter, clearer boundary around what the law considers truly involuntary action.
Wow. It really shows how one single awful incident on a roadside can push the entire legal system to clarify something so fundamental. But the impact wasn't just confined to legal textbooks and courtrooms, was it?
No, definitely not. The Eadie case, especially some of the comments made during sentencing by the trial judge, Justice Griesel, really put the whole phenomenon of road rage into the public spotlight. Griesel specifically mentioned how common the issue is, talking about traffic, frustration, stress, anger, and how they all contribute to aggression on the roads. And the Supreme Court of Appeal echoed this concern. They agreed with a sentiment from another road rage case, S. v. Salico, saying it's just wholly unacceptable for drivers to basically execute someone else at the scene of a collision or dispute.
And it's important to remember, in the Eadie case, both men involved were heavily intoxicated. Both contributed to the situation escalating. Eadie was provoked. Duncan did behave badly. But the court was crystal clear on this point, wasn't it?
Absolutely emphatic. Duncan's aggressive and provocative behavior, the court stated very clearly, did not entitle the appellant Eadie to behave as he did, full stop.
So the message seems pretty stark.
It is. This case sends a very clear message. Consciously giving in to your anger or other strong emotions to the point where you endanger someone else's life. That simply will not be tolerated by the law. It will be met with the full force of legal consequences. That defense of lacking self-control, of incapacity, it's reserved for those truly rare, exceptional instances of genuine automatism. Not for situations where someone just snaps out of fury, and the courts have to apply this principle consistently, really, to maintain public confidence in the justice system.
And that really wraps up our deep dive into SV Eadie. We've seen how this incredibly tragic road rage incident forced a legal reckoning, becoming a watershed moment. It clarified the very narrow, very exceptional circumstances under which someone can successfully claim they weren't criminally responsible because they truly lost control.
Yeah, it underscores the legal system's fundamental expectation, maybe even demand, for individual accountability and self-control. It's a stark reminder that while our emotions can be incredibly powerful, the law draws a very definite line between feeling overwhelmed by strong emotions and a complete involuntary inability to control your actions.
So thinking about this deep dive into losing control,
Right.
what does it maybe tell us about our own accountability? Not just in those extreme moments, maybe, but in the everyday frustrations we all face. Something to mull over, perhaps, until our next deep dive. Thanks for listening.